HOA Karen brought 5 lawyers to take my woodlet. I was chairing the hearing. What happens when 5 lawyers show up determined to take someone's woodlet? And how does everything change when the person they came to challenge is chairing the hearing? Hello, everyone, and welcome back to the channel. I am glad you are here for another unforgettable neighborhood justice story. Before we begin, please subscribe to the channel and turn on notifications so you never miss our next story. Thank you for watching, supporting the channel, and continuing to spend your time with us. Your support truly means a lot. Before we get started, tell me in the comments, where in the world are you watching from, and what time is it there right now? Let's begin the story. That's the man who thinks 26 acres of trees make him untouchable. Victoria Caldwell said it just loudly enough for the people nearest her to hear, and just quietly enough to pretend she had not meant for me to. 5 lawyers followed her through the double doors of the county hearing room, each carrying a leather briefcase or a thick accordion folder packed with exhibits. Their shoes clicked across the polished floor in a steady rhythm. Mine did not. I was already seated behind the raised dais, one hand resting beside the microphone, a county binder open in front of me. The room smelled like old carpet, printer paper, and coffee that had been sitting on a warmer too long. Victoria stopped halfway down the aisle when she finally looked up. For 3 seconds, nobody moved. Her expression changed in stages. Confidence first, confusion second, then recognition. She glanced at the brass nameplate in front of me. Grant Whitaker, Chair, County Land Use Appeals Board. The lead attorney beside her, Paul Brennan, followed her eyes to the nameplate, then back to me. His jaw tightened almost imperceptibly. I leaned toward the microphone. Good evening. I am Grant Whitaker, Chair of the County Land Use Appeals Board. This hearing is now in session. A soft hum rolled through the ceiling speakers. Papers shifted. Someone in the back pulled out a chair. Victoria remained standing for another second before Paul touched the edge of the counsel table and quietly motioned for her to sit. 43 days earlier, she had stood at the edge of my woodlet and called me unreasonable. 36 days earlier, her first lawyer had told me I was misunderstanding the limits of private property. 28 days earlier, a second attorney had warned me that resisting the homeowners association could become expensive. By the time lawyer number 5 joined the team, Victoria had started telling people around Ashford Ridge that I would fold the moment the case reached a formal hearing. She had never asked what I did on Tuesday evenings. She had never wondered why a county hearing binder sometimes sat on the passenger seat of my old pickup. She had looked at work boots, a faded field jacket, and 26 acres of oak and hickory and decided she already understood me. That assumption was now sitting beside her in 5 expensive suits. The clerk called the first 2 agenda items. Routine variance requests. A porch setback. A drainage appeal. I handled both the same way I handled every hearing. Calmly. By the record. Victoria barely listened. She kept whispering with her attorneys and glancing toward me. Then the clerk turned the page. Next matter. Petition submitted by Ashford Ridge Homeowners Association concerning access across Parcel 17B, currently owned by Grant Whitaker. The room went still again. I closed the binder in front of me. Before this matter proceeds, I need to disclose that I own the affected parcel. Victoria's eyes narrowed, almost hopeful, like she thought she had just discovered a way out. I continued. Because of that conflict, I will not participate in deliberation or vote on the merits. Vice Chair Rebecca Ames will preside over this item. Rebecca moved toward the center microphone. I stepped down from the dais and carried my folder to the table reserved for property owners. Victoria watched me the entire way. She still did not understand what had happened. She thought my recusal had removed my advantage. What she did not know was that I had never needed the chair to protect my land. I needed the record, and she had spent 43 days building it for me. 43 days before the hearing, the only sound in my woodlet was wind moving through oak leaves and the dry click of cicadas warming up in the morning heat. I had owned those 26 acres for 12 years, but the land had been in my family much longer than that. My father bought it in 1978 when the area outside Ashford Ridge was mostly pasture, scattered farmhouses, and narrow county roads with grass growing along the shoulders. He never built anything fancy on it. No house, no barn, just an old logging path, a small equipment shed, and a habit of walking the boundary twice a year with a red roll of survey ribbon in his pocket. When I inherited the property, I kept doing the same thing. Not because I was sentimental about every tree, but because land has a way of teaching you what gets forgotten when people stop paying attention. I worked as a forestry consultant for most of my career, helping landowners manage timber, erosion, access, and conservation plans. That meant I spent a lot of time in boots, field jackets, and old pickup trucks. Most people who met me on the property assumed that was the whole story. I never corrected them unless there was a reason. That morning, I was replacing a faded red survey ribbon on a white oak near the eastern boundary when I heard tires crunching over gravel. A white Lexus stopped near the old logging entrance. Victoria Caldwell stepped out wearing cream-colored slacks, a navy blouse, and shoes that had no business being within 50 feet of wet leaves. She looked around like she was evaluating a listing. "Mr. Whitaker," she called. I tied the ribbon, pulled it tight, and turned toward her. "That is me." She introduced herself as president of the Ashford Ridge Homeowners Association, though I already knew who she was. Ashford Ridge bordered my property on two sides, a polished subdivision with stone entrance pillars, matching mailboxes, and a clubhouse roofline visible through the trees in winter. Victoria held a rolled site plan under one arm. "We need to discuss access. Not ask about access. Discuss it." She spread the plan across the hood of my pickup. A red line ran from the subdivision road, through my woodlet, and toward the back of their clubhouse property, about 30 feet wide from one side to the other. "What is that?" I asked. "A proposed community connection. Across my land. Across an underused section of your land." I looked at her. She smiled like the wording should have made a difference. According to her, the route would improve emergency access, create a walking trail, and help maintenance crews reach drainage infrastructure behind the clubhouse. She talked fast and confidently, using phrases like shared benefit and community necessity. I listened until she finished. Then I pointed at the red line. "Do you have an easement?" Victoria folded her hands over the map. "Our attorneys believe we can establish one." That was not my question. Her smile tightened. "Mr. Whitaker, this is 26 acres of trees. We are talking about a narrow strip along the edge." I looked past her toward the white oak with the fresh red ribbon tied around it. My father had marked the same boundary for decades. Then it should be easy to go around. Victoria exhaled slowly, like I was disappointing her. Progress does not always work that way. She rolled the map back up and glanced through the open passenger window of my truck. My county hearing binder was sitting on the seat beneath a pair of work gloves. She looked directly at it, then away without interest. "We will have counsel contact you," she said. I nodded. "Have them send everything in writing." She paused. "You are making this harder than it needs to be." I looked at the survey ribbon moving lightly in the breeze. "No," I said. "I am making sure the line stays where it belongs." The first letter arrived 4 days later. Heavy cream paper inside an overnight envelope that cost more to ship than most people spend on lunch. The return address belonged to Brennan, Cole, and Mercer, a regional law firm with an office downtown and a website full of marble conference tables. Paul Brennan introduced himself as counsel for Ashford Ridge and explained, in 3 dense pages, why the Homeowners Association believed a historic access right might exist across my woodlet. I was doing a lot of work. He referenced an old logging path, emergency access principles, community necessity, and something called implied historical use. What he did not include was a recorded easement. I read the letter twice at my kitchen table while rain tapped against the windows. Then I punched 2 holes in it and added it to a binder. The second lawyer contacted me 3 days later. Zoning specialist. She argued that the proposed connection supported public safety and regional planning goals. Binder. The third specialized in homeowners association law and suggested that continued refusal could expose me to substantial legal expenses. Binder. The fourth focused on environmental review and claimed a controlled access route might actually reduce unmanaged foot traffic through the woods. Binder. By the time the fifth attorney sent a litigation notice, Victoria had assembled enough legal stationery to wallpaper my equipment shed. I did not answer with anger. I answered every letter the same way. "Please provide the recorded instrument establishing your claimed right across parcel 17B. None of them did. Instead, survey crews began appearing near the eastern boundary. They stayed on the Ashford Ridge side, but their fluorescent stakes kept getting closer to my red ribbons. One Thursday morning, I found Victoria standing beside a survey truck while 2 technicians studied a map on the tailgate. The woods smelled like damp bark and pine needles after an overnight storm. 5 lawyers, I said. That seems expensive for a narrow strip nobody needs. She smiled without looking at me. It is only expensive when someone refuses to be reasonable. Do any of them have an easement yet? That got her attention. Grant, you are treating this like some family garden. Ashford Ridge has more than 300 homeowners. We have obligations. And I have a deed. She stepped around a puddle, careful not to splash her shoes. You really believe a piece of paper from 1978 is going to stop a modern land use petition? Depends what the paper says. Her expression sharpened. You know, people around here think you are holding an entire community hostage over trees. I looked toward the white oak where my father's red ribbon moved in the breeze. People around here are free to think whatever they want. Our attorneys are preparing for a formal hearing. Good. She blinked. She had expected resistance, maybe worry. Not that. Good. File whatever you believe you can prove. For the first time, the confidence slipped slightly. I could almost see her recalculating. Then it returned. You will understand the situation once you are sitting across from 5 attorneys. I closed the gate to the logging path and rested one hand on the latch. Before you file anything, Victoria, let me give you one piece of advice. She folded her arms. I am listening. Make sure you want every claim you are making put into the official record. She laughed softly. Absolutely. That word stayed with me. Absolutely. 2 weeks later, I would read the petition her lawyers filed with the county. 27 pages, 6 exhibits, 3 sworn statements, and 1 sentence that should never have made it past the first draft. The petition arrived on a Monday morning, 27 pages held together with a black metal clip and delivered by certified mail before I had finished my first cup of coffee. I carried it to the workshop, cleared a space beside my field maps, and started reading from page 1. The language was polished. Expensive. Ashford Ridge described the proposed access across my woodlet as necessary for public safety, emergency response, drainage maintenance, and pedestrian connectivity. Their lawyers called the old logging path evidence of historical access. They referred to community welfare 7 times. They referred to my ownership twice. By page 11, I had already marked 4 statements that did not match the county records. By page 17, I stopped drinking my coffee. Buried beneath a section titled Development Impact was 1 sentence. No planned commercial or residential expansion depends upon the requested access. I read it again, then a 3rd time. The workshop was quiet except for rain ticking against the metal roof. That sentence was not legal argument. It was a factual representation. Somebody had decided to put it in writing and submit it to the county as part of the official record. I drew 1 pencil line beneath it and closed the petition. I did not call Victoria. I did not call Paul Brennan. I called Elaine Foster. Elaine had served as Ashford Ridge treasurer for nearly 6 years, and unlike Victoria, she had never treated every disagreement like a campaign speech. I knew her casually from county planning workshops. When I asked whether Ashford Ridge had discussed future development near my eastern boundary, she went quiet. Why are you asking? Because the petition says no residential expansion depends on my land. Another pause. Grant, I need to check something. That evening, an electronic mail message arrived from Elaine with a scanned board packet attached. The document was dated 8 months earlier. Phase 2 Feasibility Review. I opened the map first. 41 proposed homes appeared on a parcel behind the existing subdivision. A red transportation line ran from those homes toward the clubhouse road. It crossed one obstacle before connecting to the rest of Ashford Ridge. My woodlet. The same 30-foot strip Victoria had called emergency access. I kept reading. 1 page described the route as essential for Phase 2 marketability and internal circulation. At the bottom was an acknowledgement line. Victoria Caldwell, President. Her signature sat there in blue ink. I pulled the county petition back across the table and placed the 2 documents side by side. No planned residential expansion depends upon the requested access. Essential for Phase 2 marketability. Same access, same land, same signature. The smell of wet soil drifted through the cracked workshop door while I stared at both pages. That was when the dispute changed for me. Before that moment, Victoria had been trying to pressure me into granting an easement. Now she had submitted a statement to a public body that appeared to contradict her own internal planning documents. I called Elaine again. Was Phase 2 approved by the homeowners? No, she said. It was preliminary. Victoria told us access questions would be resolved before anything went forward. Did the board authorize her to say the woodlet access had no connection to Phase 2? Not that I remember. I wrote down her answer, the date, and the time. Then I placed the Phase 2 packet in the same binder as the 5 attorney letters. Outside, the rain had stopped. Water dripped from the oak leaves behind the workshop, slow and steady. Victoria had spent weeks trying to convince me that 5 lawyers gave her leverage. But 5 lawyers could not make 2 contradictory documents agree. And the hearing was getting closer. For the next 10 days, I said almost nothing to Victoria Caldwell. That silence seemed to make her more confident. Every few days, another message arrived from one of her attorneys reminding me that the hearing date was approaching and suggesting that a voluntary easement would save everyone time and expense. I printed each one, dated it, and added it to the binder. Then I went back to the documents that actually mattered. The 1978 deed was first. I spread the original copy across my workshop table beneath a bright task lamp and read every line slowly. 26 acres conveyed to my father. Timber rights included. Mineral rights reserved under an older agreement. 1 utility easement along the southern edge for overhead electrical service. Nothing across the eastern boundary. Nothing mentioning Ashford Ridge. Nothing granting public access. The next morning, I met Henry Dalton at the Woodlet. Henry had been surveying property in the county for more than 30 years and still carried a field notebook even though most of his equipment was digital now. The air smelled like oak leaves and damp soil as we walked the old logging trail. He checked the iron pins, compared modern coordinates with an archived plat, and stopped beside the white oak where my red ribbon moved in the breeze. "Your line is clean," he said. "Always has been. Any evidence this trail was ever a public road?" Henry shook his head. "Logging access. Private. I surveyed the western parcel in 1994. Same thing then." I asked him to put that conclusion in writing. He looked at me over his glasses. "Hearing coming up? Soon. Then I will make it boring." That was exactly what I wanted. Boring facts survive dramatic arguments. After Henry left, I drove to the county archive and pulled historical aerial photographs going back decades. In 1982, the logging trail ended inside the woods. In 1996, same thing. In 2008, Ashford Ridge had already begun growing along the boundary, but there was still no connecting road. No public route. No neighborhood access. Just trees and the narrow track my father had used to move equipment. I copied every image. By then, my binder had 4 clean sections. Deed. Survey. Historical records. Ashford Ridge filings. Victoria had 5 lawyers. I had tabs. 3 days before the hearing, I attended a routine county planning session. I was leaving the building when I heard Victoria's voice behind me in the hallway. She was speaking to Paul Brennan. "Once we get the access approved, Phase 2 can finally move." I kept walking. She had no idea I was close enough to hear. Paul answered too quietly for me to make out the words, but the sentence was enough to confirm what the documents already showed. Later that afternoon, Elaine forwarded another board record. Meeting minutes from 7 months earlier. Victoria had presented the Phase 2 map herself. The minutes specifically described my woodlet crossing as the preferred internal connection. At the bottom of the packet was her acknowledgement signature. I placed that page beside the county petition and stared at the 2 statements again. No residential expansion depends upon the requested access. Preferred internal connection for Phase 2 development. Same woman. Same project. 2 different stories. That evening, Victoria called me directly for the first time in weeks. "Grant, this is your last chance to settle before we appear in front of the board." I looked through the workshop window at the red ribbon tied to the oak. "I am comfortable with the hearing." She gave a small laugh. "You should know Paul is bringing the full legal team." "I know. 5 attorneys. You mentioned that." Her voice cooled. "You really think you can walk into that room with an old deed and stop us?" I closed the binder. "Victoria, I am not worried about what I am bringing into that room." There was a pause. "Then what are you worried about?" I looked at her signature on the 2 contradictory records. "What you already brought." The night before the hearing, I slept better than Victoria probably expected me to. By 7 the next morning, I was already inside the county administration building, carrying the same dark binder that had spent weeks riding on the passenger seat of my pickup. The hallway smelled like floor wax, copier toner, and burnt coffee from the vending alcove. I had chaired enough hearings to know that confidence usually got loudest right before the record started asking questions. At 8:45, Vice Chair Rebecca Ames arrived with County Counsel Thomas Reed. I met them in the conference room behind the hearing chamber and disclosed everything formally. My ownership, the Ashford Ridge petition, every communication I had received, every document I intended to submit as the affected landowner. Thomas reviewed the disclosure, then nodded. You open the session, announce the conflict, and step away from deliberation and voting. Exactly. Rebecca looked at the binder under my arm. They know you are chair? Victoria does not. She raised one eyebrow. That should be an interesting 30 seconds. At 9:15, the public doors opened. Residents filed in. Chairs scraped across the floor. Microphones clicked alive one by one. Then came the sound I remembered most clearly. 5 leather briefcases closing almost in sequence near the entrance. Victoria entered beside Paul Brennan and 4 other attorneys, all in dark suits, all carrying enough paper to make the dispute look larger than 26 acres of woods. She spotted me behind the dais and slowed. That is the man, she murmured to Paul. The one refusing the access. Paul looked up. His eyes landed on the brass nameplate in front of me. Grant Whitaker, chair. The whispering stopped. I leaned toward the microphone. Good morning. I am Grant Whitaker, chair of the County Land Use Appeals Board. We will now call this session to order. Victoria stared at me like the room had changed shape around her. Paul immediately opened a folder and began whispering to another attorney. I handled the first agenda items normally. A setback request, a drainage variance, a sign appeal. Then the clerk reached Ashford Ridge. Next matter concerns a petition for access across parcel 17B, owned by Grant Whitaker. I closed my county binder. Before we proceed, I need to disclose that I am the owner of the affected property. I will therefore recuse myself from deliberation and voting on this matter. Vice Chair Rebecca Ames will preside. I stepped down from the dais and carried my documents to the property owner table. Victoria's face changed again. Relief this time. She leaned toward Paul. So he cannot decide it. Thomas Reed heard her. That is correct, he said from the county council table. Chair Whitaker will not decide this matter. However, all petitions, affidavits, exhibits, and factual representations submitted by Ashford Ridge remain part of the official record and are subject to review during the hearing. Paul stopped turning pages. Victoria looked at him, then at me. That was the moment she finally understood the part she had missed. My position on the board was never the weapon. Recusing myself removed even the appearance that I might use it that way. What remained was cleaner. Her petition, her signatures, her sworn statements, her 5 attorneys, and 43 days of paperwork that could not all be true at the same time. Rebecca adjusted the microphone. Counsel for Ashford Ridge, you may begin. Paul stood slowly. I opened my binder to the 1978 deed and waited for the paper to start talking. Paul Brennan began with the version of the story Ashford Ridge had spent weeks polishing. He called the old logging trail a historical access corridor. He described the proposed 30-foot connection as a limited community necessity. He emphasized emergency response, drainage maintenance, and public safety. His voice was measured, professional, almost soothing. If I had not owned the land, I might have believed him. Rebecca let him finish. Then she looked at me. Mr. Whitaker, your response. I stood, carried one folder to the evidence table, and opened it. I would like to begin with the deed. Thomas Reed marked the document as an exhibit. The 1978 deed was plain, yellowed at the edges, and much less impressive than the glossy maps stacked beside Paul. That was fine. Pretty paper does not change property lines. I walked the board through the recorded easements. One electrical corridor on the southern edge. No public roadway. No community access. No language granting Ashford Ridge any right across the eastern boundary. Paul objected that historical use could establish additional rights. Rebecca nodded toward me. Do you have evidence addressing historical use? Yes. Henry Dalton stepped forward next. He had brought his survey notes, archived plats, and a quiet voice that made every sentence sound like it had already been checked twice. He explained the iron pins, the eastern boundary, and the old logging path. Private timber access, he said, never shown as a county road, subdivision road, or recorded easement. I submitted photographs of the white oak and the red survey ribbon marking the same boundary Henry had verified. Then came the aerial images. 1982, 1996, 2008. Different tree growth, different development around the property. Same result. The logging trail ended inside my woodlet every time. No connection to Ashford Ridge. Paul began conferring with two attorneys at his table. Their whispering grew faster. Victoria sat perfectly still. Then Rebecca asked the question I had been waiting for. Ashford Ridge also states that no planned residential expansion depends upon this access. Is that correct? Paul looked at Victoria before answering. That is the association's representation. I opened the next tab in my binder. Then I would like to submit the Phase 2 feasibility packet. Victoria's head turned toward me. The room went quiet enough to hear the air conditioner cycling above us. Thomas marked the packet. I placed the map on the display easel. 41 proposed homes. Clubhouse Road. One red route crossing my property. At the bottom of the planning page were the words essential for Phase 2 marketability and internal circulation. Victoria Caldwell's signature appeared underneath. Rebecca leaned forward. Mrs. Caldwell, are you familiar with this document? Victoria adjusted her glasses. I have seen many preliminary concepts. Did you approve this one? I would need to review the context. Elaine Foster stood from the second row when her name was called. She had brought the original board packet and meeting minutes. Her hands trembled slightly when she placed them on the table, but her voice did not. Victoria presented that map to us 7 months ago. Victoria looked over sharply. Elaine continued. She said the Woodlet connection was the preferred route for Phase 2. Paul rose. The development was preliminary. Rebecca held up one hand. That is not the question. She turned back to Elaine. Did the board authorize the statement that no residential expansion depended upon the requested access? No. Paper stopped moving at the Ashford Ridge table. One attorney leaned toward Paul. Another closed a laptop. Victoria stared at Elaine like she had broken some private rule by answering honestly. Rebecca then placed the petition beside the Phase 2 packet. 2 documents. 2 statements. 1 signature. Paul asked for a short recess. Rebecca granted 10 minutes. The 5 lawyers immediately pulled their chairs together and began whispering over the table. Victoria tried to join them, but Paul quietly raised a hand and asked for a moment with counsel. I sat across the room and looked at the old deed in front of me. Victoria had believed the hearing would be about whether 5 lawyers could make my woodlet seem available. It was becoming something much simpler. Which version of her own record was the board supposed to believe? The recess lasted 11 minutes. When Paul Brennan returned to the counsel table, he looked different. Not defeated. More careful. The 5 attorneys sat down in a tighter row, their folders rearranged, laptops closed, voices lowered. Victoria remained standing for a moment, arms folded, watching them like she expected someone to restore the room to the version she had planned. Nobody did. Rebecca called the hearing back to order. Paul rose. Ashford Ridge would like to clarify the scope of its petition. That sentence told me everything. Lawyers do not narrow a request when they believe the original one is working. He explained that the association was willing to remove references to broader community connectivity and focus only on emergency and maintenance access. Rebecca looked down at the petition. Counsel, the filing before us requests a permanent 30-foot corridor and represents that no residential expansion depends upon that corridor. Are you withdrawing portions of your own application? Paul paused. We are refining the requested relief. Thomas Reed leaned toward his microphone. The board cannot evaluate a materially different petition without proper notice and a complete factual record. One of the attorneys beside Paul whispered something. Victoria finally leaned forward. This is becoming ridiculous. Everyone knows the access is needed. Rebecca turned to her. Mrs. Caldwell, needed for what? Victoria opened her mouth, then stopped. That silence carried farther than anything she had said all morning. Rebecca picked up the Phase 2 packet. This document says the route is essential for future residential development. Your petition says no residential development depends on it. Those statements cannot both describe the same purpose. Victoria looked toward Paul. He did not answer for her. Elaine sat 3 rows back, hands folded in her lap, watching quietly. I stayed at the property owner table with the deed closed in front of me. There was nothing left to add. The record had already done the work. Paul asked whether the board would consider continuing the matter to a later date. Thomas responded before Rebecca could. A continuance does not resolve inaccurate factual representations already submitted. That was the sentence that changed the air in the room. 2 of the attorneys began gathering loose pages. Another turned off a tablet. One leather briefcase clicked shut. Then a second. Rebecca reviewed the evidence one final time. No recorded easement. No historical public road. No demonstrated emergency necessity independent of the proposed development. A direct conflict between the public petition and Ashford Ridge's internal planning documents. She looked to the remaining eligible board members. I will entertain a motion. A member to her left spoke clearly. Motion to deny the petition based on insufficient evidence of access rights and material inconsistencies in the stated purpose. Second, the vote was not dramatic. No shouting. No applause. Just hands, microphones, and a clerk recording the result. Petition denied. Rebecca then added that the conflicting representations would be referred to County Council for separate administrative review. Victoria stared at the table. Paul began packing his documents. The 5 lawyers who had entered carrying boxes, maps, and confidence were now closing their briefcases one after another. Victoria turned toward me as I stood to collect my binder. "You set me up." Her voice was low, but the room was quiet enough that several people heard it. I looked at her, then at the petition bearing her signature. "No, Victoria. I asked you to tell the truth on paper." She had no answer for that. I slid the old deed back into my binder. Behind me, the final briefcase snapped shut. The week after the hearing, the letters stopped. No certified envelopes waited in my mailbox. No survey trucks idled near the eastern boundary. No attorneys called to explain what 5 previous attorneys had somehow failed to prove. For the first time in more than a month, the woodlet sounded like itself again. Wind moved through the oak canopy. Acorns clicked against the roof of the equipment shed. Somewhere beyond the logging trail, a woodpecker worked steadily against a dead hickory. County Council continued reviewing the conflicting filings, but I stayed out of that process. I had already done what I needed to do. I had protected my land without using my position to decide my own case. 2 weeks later, Elaine Foster called me. Ashford Ridge had scheduled a special homeowners meeting. Residents wanted answers about the legal expenses, the Phase 2 plan, and why the board had been told the woodlet access was primarily about emergency safety when internal documents described it as essential to future development. I did not attend. It was their association, their money, and their decision. 3 nights later, Elaine called again. Victoria Caldwell had been removed as president by a homeowner vote. Phase 2 had been suspended pending an independent review, and the proposed route through my property had been taken off the planning map. I thanked Elaine and went back to sharpening a chainsaw chain at my workbench. There was no celebration, no champagne, no victory speech, just the quiet satisfaction of knowing that nobody was coming through those trees without my permission. By early October, the first cold mornings settled over the county. I walked the eastern boundary wearing the same faded field jacket Victoria had probably mistaken for proof that I did not understand people like her. Fallen leaves covered the old logging trail in red and gold. When I reached the white oak, the survey ribbon my father's generation had used was still tied around the trunk. The red had faded slightly under weeks of sun and rain, but it was still visible against the gray bark. I replaced it with a fresh strip and checked the permanent marker Henry Dalton had verified, exactly where it belonged. On my way back, I stopped beside the pickup and opened the passenger door. The county hearing binder sat beneath my work gloves, just as it had the morning Victoria first came to the property. I looked at it for a second, then closed the door. That binder had never been a threat. Neither had the chair behind the county dais. Real authority was never about making someone afraid of your title. It was about knowing where your responsibility ended, where the law began, and having the patience to let facts survive longer than pressure. Victoria had come into that hearing believing 5 lawyers could create a right that the deed did not contain. She believed enough polished arguments could make an old boundary feel negotiable. But the woods did not care how many briefcases she carried. The survey did not care. The deed did not care. The record certainly did not care. I stood beneath the oak trees while a cool breeze moved through the branches above me. She came from my woods with 5 lawyers. In the end, the only thing that mattered was the one thing none of them could argue with, the record.